There are no cameras here. And I'm starting to get the feeling my 15 seconds of fame on King TV have come and gone. But, oh, there he is, stretching. I stand corrected.
Thank you, Your Honor. We got to keep our voices up. We want to make sure we got a good sound.
Should we bring these forward? Or do it like that?
Let's keep the voices up. Thank you, Your Honor. The respondent has appeared at many of the public events that I attend, both in the capacity as an activist and as a musician. When the respondent appears, he keeps me under surveillance with his video camcorder, and he starts persistently and incessantly screaming conspiracy and murder and corruption allegations at me. If it's in a private venue, the respondent is asked to leave. He always refuses to leave, and he must be forcefully removed. On 2 occasions when he was forcefully removed, he screamed at me, "I will get you, Novoselic." This caused me to be alarmed, and his behavior is very annoying to me. The only way I could, if he's not, and if it's in a public place, I have to basically flee on foot or hide behind a door or get in a car. It's so incessant and so persistent. And I've tried courtesy, I've tried to be reasonable, and I've tried to ignore him, and it just doesn't work. And after 6 years, I've pretty much reached the end of my rope, and I filed an anti-harassment order.
You want to talk about any particular speaking? Is there anything you want to add about those particular?
I appeared at a public meeting a public hearing to express my opinion over a relevant issue in regards to an ordinance that jam-packed.
The city dance ordinance, I believe is what it's called.
The all-ages dance ordinance.
Right.
I appeared with a couple of colleagues, and Mr. Lee ambushed me and my colleagues and took advantage that he was in a public place. He took his camcorder and put it inches from my face and started stating corruption and conspiracy theories at me. And I tried to cover the camera, I tried to ignore him, I tried to walk away, and to no avail. He just persistently harassed me and followed me. The security guard, his behavior not only alarmed myself, but alarmed the rest of the people who were in that hearing. And security guard called the Seattle Police Department, and I had to be, and my colleagues and I had to be escorted out of the building after I made my testimony.
Well, hey kids, here we are out back of Freeway Park, site of a recent murder victim in the bathroom stall thingy. If you've ever walked through this place, you know that there's no more perfect place in Seattle for a murder to occur in broad daylight or any other time, unless it happens to be that place. Or should we say those places? Yeah, something tells me Osama bin Laden's got that place on his hard drive somewhere, you know what I mean? Twin towers, extremely conspicuous by the freeway, you know, seen by hundreds of thousands, if not millions of people a week. Yeah, there could be a big broad daylight murder thingy down that way. But probably more about that later. Anyway, yeah, it's scary to walk through the great park for dope dealers and hookers and anyone else, you know, freeway park, just up here behind all the hotels and stuff. Not to say that there's flagrant drug traffic going on. There's just a lot of seedy dudes hanging around, and, well, take a visit sometime. You'll see what I mean. Anyway, this is where you can park your motor scooter or anything else to go to the C of A. And by C of A, I mean not the City of Angels, but the Court of Appeals, where we were today. With our little scrawly notes on Lee versus Novoselic, as it is now known. The Lee petitioner, soon to be appellant, presumably, and Novoselic respondent. And it's drizzling, and I don't want to damage my little notes here, and we'll have a complete audio tape within a few days, so they tell us. So we'll probably be playing that. Don't know precisely why I'm doing a monologue here, because I don't want to get into the whole thing, except that I'm quite happy that things went so swimmingly well. I had a fairly, Commissioner Neal was fairly polite and let us even go over our time a couple of times, and we made all our good points about how this is all going to be terribly devastating to the First Amendment for investigative journalists and all that. And yeah, Ms. Stevens, our opposing counselor, just didn't know have a hell of a lot to say, except, you know, that they're standing on what they've written already, which again is just a reiteration of the same old crapola about he's obsessed with my client. I'm not obsessed with your client, Toots. I think he's a colossal bore. Aren't most murderers colossal bores? Oh wait, I didn't mean to call him a murderer. I mean, he's at the dead center of a murder conspiracy, which I did explain. I even went off on that before Commissioner Neal and said, you know, at the very moment before they assaulted me, I was asking him about a hitman in Los Angeles who was propositioned with $50,000 by his business partner to kill his other business partner. That's what they're objecting to, not the manner of what I'm doing, but the content of what I'm doing. And curiously enough, Judge Roystocker was all on board with that. So for our opponents in this thing, which are Novoselic, you know, and everyone around him, including CLC, the person he's, you know, facing in litigation over Nirvana Incorporated, and Mr. G, you know who he is, and the other Mr. G above him, Alan's buddy, you know. Yeah, they're all, this is the day that they wished had never happened, the day when, you know, I followed procedure carefully enough and authored my responses to their arguments well enough so that if C of A doesn't endorse this thing for discretionary review and basically put it into the electronic record of American legal history forever and ever, then there's something terribly wrong with C of A, you know. But they're gonna, they don't apparently issue many oral pronouncements, decisions on a case of this complexity, which is good. I respect that. So we'll be awaiting the reaction in the mail, and I think we'll get it because it seems to fit all four of the prongs of RAP 2.3D. So, yeah, we'll be looking forward to victory being ours. Victory is mine, baby. The day that they always feared would happen. That I'd follow the appeal through to the point where Novoselic is no longer now a famous defender of the First Amendment, but a famous basher of the First Amendment when it suits his purposes. Which means as far as winning the ACLU Torch of Liberty or whatever, Medal of Liberty, Torch of Freedom, whatever they're giving Larry Flint this, you know, last year, you know, Courtney Love next year, right? Maybe. He ain't gonna be in line for one of those suckers because he'll be designated as a clear opponent of free speech when it comes to the serious business of investigative journalism and not the unserious business of, you know, hawking CDs to gullible teens. And just to conclude, I'll say that on that account, point out one thing which in fact goes on right in that building. You know what those Twin Towers are actually most famous for? In these United States and presumably internationally, as the home of MTV's Real World, when they were doing their intern gig at Candyland. Yeah, kids. And now, I've listened to this station only occasionally. I listen to radio fairly often, quite a lot, but this station has always been completely unlistenable, although it is the top-rated station, and it is the station that covers this whole grunge thing, but believe me, most of the crap they play, boy, I feel sorry for these kids today, it's completely unlistenable crapola. And the really weird thing is that, I was listening a few months ago just for like an hour, and then I did tune in specifically on Wednesday, because Wednesday is, get out your hankies, kids, Wednesday is the 35th anniversary of the birth of Kurt Cobain 2 days ago. Yeah, Kurt would have been 35, Of course, he would have been all played out and fucked up by 35. Who's 35 and still worth a good goddamn, right? Well, yours truly, I'm way past that, kids. And I'm still worth a damn. But in the past, the spiel that they developed on this thing was, we're not going to celebrate the death day. They actually have said this. We're not going to celebrate the day of his death, April 8th, or as they later interpreted it and apparently told the BBC, it's April 5th that they really think that they should be recognizing. I think this guy calls himself Steve the Producer was on Channel 13 when they covered the fact of the BBC being here, and the BBC had the bright idea that the big anniversary is the 5th too, just because that's on the death certificate, right? So they've said in the past, hey man, we're gonna celebrate Kurt's birthday, baby. Get away from all this death thing, But I listened to that station for about 4 hours on Wednesday night, and not one effing reference to Nirvana or anything else directly related to the fact of Mr. Cobain and the fact of his birth and the fact of his death and the fact that his birth occurred precisely 35 years before, which was, according to a Walter Cronkite thing I heard on NPR, that was the 5th anniversary of the John Glenn space shot. I didn't know that. So Cobain was born on the 5th anniversary of the space shot, the first orbital shot. And so yeah, and I heard 2 of the news that you can use features by this Steve the Producer guy, and in fact he even mentioned other grungy things like Scott Weiland, Courtney's sometimes buddy or drug buddy or buddy in rehab or whatever they got going, getting back together with his wife. Well, that's super significant news, but it's the 35th anniversary of the day that 2 years ago you said was like practically the national fucking grunge holiday. And they didn't acknowledge it at all in the approximately 4 hours that I heard. And of course, the reason I did this is that previously, I've taped, their routine about Kurt this, Kurt that, whatever, on the anniversary of the date of the death. They're all so fucking sad. He made them so much fucking money, in the colossal MTV empire of which KNDD is a part. But they let that 35th birthday thing slide, baby. And, and then of course the last thing to mention is that of course it's a great thing that they just leave, why don't they just leave Kurt Cobain completely out of the crap that they do, because it's so fucking offensive. Everything they say is like completely, it's geared toward like a 15-year-old mentality, and it's all about veiled references to drugs and partying and excessive masturbation, It's so disgusting. And yet this is the primary advertising organ for this whole Seattle rock scene, and it's completely, believe me, it's not just that I'm against media aimed at teenagers. It's really just, it's always offensive. Like there's that polyester club across the street from Paul Allen's joint, and they got this ad where this like female squeals, "Wine me, dine me, 69 me," you know, which, you know, if it was said once it would be kind of funny, but it's played over and over again repetitively so that every, you know, teenager in a tri-county area has that indelibly tattooed to their brain. And it's not that the phrase is offensive, it's just all of this mental programming that they're doing to the kiddies, all of the mental program that's geared toward consumption of drugs and sex and rock and roll, which, let's face it, kids, if you don't find out, I mean, if you don't get into those things casually and on a basis that you can handle, are quite destructive and no fun at all when you're merely playing into them as a part of a victimized underclass that's having its free will sucked away by the aggressive social engineers of MTV. And I'm not going to make any jokes about how fortunately the joint is on Osama's hit list, you know. I used to work in that place. And it's scary, too. This was 3 years ago, and believe me, there was an atmosphere of constant tension there regarding safety and security in the building at the Met Towers, you know. And gee whiz, I'll bet it's even more tense these days. You could take those things out with a couple of Piper Cubs, you know, if they were well stocked with some C4 stolen from Fort Lewis. The Met Towers would go down real fast. So that's the grim possibility and the good news of the day, which is that everything is going along swimmingly in terms of everything I filed with C of A on Lee versus Novoselic, and hopefully we'll be headed toward writing an extensive brief championing the First Amendment, which Novoselic's lawyer today said, and my client, Chris Novoselic, he knows that the First Amendment is an important amendment. He knows that the First Amendment is an important amendment. Gee, no shit, princess. Ain't they all? Ain't they all? It really, he knows that. It really is one of those important amendments. So, victory is mine, I'm predicting. And if not, I did everything I could pretty damn well, so if there's a miscarriage of justice, it's a miscarriage of justice and a demonstration of how appeals don't work. But my perception is that they'll be pretty greedy to get their hands on this thing because it's such a great First Amendment case and it makes the whole appeals thing look terribly important. And if they don't, I'll just have to see. What did the Seattle Weekly say? Oh, right, yeah, if things don't go my way, I'll just say, obviously Courtney Love bought them off. Which isn't my only argument when things go poorly. I also say the entirety of the legal community and political apparatus in Seatown can be aimed against one. And that's the only basis for this thing being defeated that I can see. So, hopefully victory is ours.
can address your sanctions motion when you're making your argument. Go ahead.
Well, good morning, Commissioner Neal. My name is Richard Lee. I'm representing myself pro se, as you may know or may have noticed. And I provided, just to double check, the court has received a 23-page document from me this week, which is my response to the motion for...
I assume so. Yes.
All right. And if I had to take a guess, I'm saying that we'll be anticipating a written response rather than a ruling today. Is that correct?
Absolutely.
All right. Well, then I'll just anticipate that everything's in order. Justice Louis Brandeis, quoted in Sullivan versus New York Times, said that sunlight is the best disinfectant. And this is a phrase which has, entered public policy discussion to the extent that it's almost a cliche. But I would say that it does have a direct bearing on this particular case because you have to realize that photography is a function of having sunlight present. And for more than 100 years, photography has been an important part of journalism. That is, with the sole exception of the Wall Street Journal, there really is no national journal of wide circulation that functions without a great deal of photography as a part of its journalism. And for more than 50 years now, journalism has been assisted, the public has been assisted in its understanding of public policy developments and issues by television. For instance, the Korean War was covered on television at a time when television camera setups weighed in excess of 500 pounds. Also, television allowed extensive examination of things like the Kefauver Committee hearings on organized crime and the Watergate hearings, obviously rather famously. The petitioner, Richard Lee, who's asking for discretionary review today, has for 9 years now produced a weekly documentary series seen throughout King County on King County cable access television called Now See It Person to Person. He has produced over 500 programs in the series. And in fact, over 400 of those programs in the last 8 years have been titled or subtitled Kurt Cobain Was Murdered. This series takes into its scope of investigation a variety of public safety issues which are outside the immediate scope of the Cobain investigation, Kurt Cobain being a famous musician who died in 1994, a victim of a homicide, ruled a suicide immediately by the Seattle Police Department and the King County Medical Examiner. So approximately 200 of these programs have dealt very specifically with details regarding that particular homicide case. Now, in the course of producing this program, Richard Lee has encountered Chris Novoselic, the respondent, on 10 occasions, which he carefully detailed at trial. And on those 10 occasions, Lee encountered Novoselic in public venues, often at political events, because Novoselic is a political lobbyist and Lee is a political reporter. And these encounters almost always occurred on public property, or the majority of them occurred on public property. In fact, the November 9th, 2000 complaint by Novoselic against Lee, his declaration seeking an anti-harassment order, cites two instances, one at the Seattle City Council, September 14th of 2000, and one at the Hub Ballroom at the University of Washington, an event called Politically Incorrect. And on both of these occasions, Novoselic found a foundation for claiming that he was being harassed by today's petitioner Lee. Now, the fact is that on almost all of these occasions, I would say clearly in the majority of these occasions, Lee was violently assaulted by either Mr. Novoselic or close associates of Mr. Novoselic. This was stated at trial. Videotape was shown at trial of Mr. Lee being sprayed in the face with spray paint by Mr. Novoselic's first officer in the lobbying organization that he heads. There was videotape shown of Mr. Lee attempting to speak to Mr. Novoselic. successfully asking Mr. Novoselic about the well-known story that one of his business partners named Courtney Love offered $50,000 to a hitman, or someone she perceived to be a hitman, to kill Mr. Novoselic's other business partner, who was Kurt Cobain. Now, this is the question that Mr. Novoselic was asked on the occasion of August 21st at the Seattle City Council, at which time the respondent's first officer in his lobbying organization, named David Meinert, the person who had previously sprayed Mr. Lee in the face with spray paint, attempted strong-arm robbery of Mr. Lee's camera and the film in his camera. Now, all of this came to trial on December 8th, 2000, before Judge Pro Tem Roy Roystocker in the King County District Court, on an occasion in which Lee found Mr. Roystocker was perhaps functioning in his usual role of playing policeman between, feuding neighbors and that sort of thing, in terms of a rather odd role for a judge, but perhaps not so odd in these anti-harassment cases that come before district court, of judge more or less playing prosecutor and giving the benefit of all doubt to the side that has paid the $49 and made a series of accusations against the person who's accused of this so-called harassment. There was a lengthy hearing. Case law was discussed to some extent. Mr. Lee has a lot of complaints about the way that Judge Roy Roystocker led the proceedings, including a variety of interruptions of Mr. Lee putting forward his case, which the judge sort of apologized for on an ongoing basis, but while still conducting himself in that manner. And then Mr. Roystocker, that is Judge Pro Tem Roystocker, offered a rather brief oral decision, which is really very substantially in conflict with a variety of the tenets of First Amendment law, not to mention the intent of RCW 1014, which is what the anti-harassment was prosecuted under. And of course, we're here for discretionary review today. My petition for discretionary review, RAP 2.3D, asks that the petitioner demonstrate a conflict with Court of Appeals or Supreme Court decisions. That's clearly the case in terms of Burchell versus Thibault, in which a person was, in which an anti-harassment order was overturned because essentially the alleged perpetrators of this harassment were prosecuted on a basis of being rude and obnoxious without further complicating factors. That's a significant case to look at. Also, Judge Roystocker continually referenced State versus Noah, which originated as Kaloff versus Noah, which is, as I understand it, presently under review by State Supreme Court here in Washington. The respondent, Ms. Stevens, also in her response to the motion for discretionary review, makes numerous references to Noah without acknowledging distinctly what the differences are between this case and Noah, which is that Noah, or Kaloff, who is a psychotherapist, is not a public figure, certainly not in the way that Novoselic, who is a political lobbyist, is, and a show business figure.
Let me interrupt you for a minute, Mr.
All right.
Lee. You've used your time.
All right.
I will give you a minute or so to wrap it up in response after Ms. Stevens goes ahead.
All right, that's fine.
Good morning, Your Honor. I will respond to the motion for discretionary review first. It's respondent's position that discretionary review is not appropriate in this instance, and I will just briefly go through the four bases. As Mr. Lee indicated, this is a decision of a district court that was heard on appeal and affirmed by the Superior Court, Judge Michael Fox sitting on that one. So RAP 2.3D is the relevant rule of appellate procedure. There are very narrow bases for granting discretionary review under that rule. The first is if the decision of the Superior Court is in conflict with decision of the Court of Appeals or the Supreme Court. That is not the case here. This court, in particular, but Washington law, has held that our RCW 10.14 is a constitutional law that allows for legitimate constitutional time, place, manner restrictions to be imposed in order to protect individuals from harassment, something that's felt to be a compelling state interest.
Is your understanding that State versus NOAA is under review?
No, actually, that's incorrect. I have that review was denied in Kayla versus K-Spear. The Supreme Court denied review, and I can give you that site.
That's all right.
But no, it isn't under review.
Thank you.
Let's see. Would you feel that State versus NOAA is the most applicable case law? It's most analogous to this situation. But just to briefly address the Birchall v. Thibault case, in which Mr. Lee erred in saying that the reason that order was overturned, that grant of an anti-harassment order was overturned, was because of rude and obnoxious behavior by the people complained of. That's actually incorrect. The reason it was overturned, as I addressed in my brief, is because despite the fact that the lower court found that the man who, Birchall, was not the subject of the harassment, that a visiting, it was a religious group, I believe, and a visiting minister had been harassed in Birchall's presence. And despite a finding by the lower court that Birchall was not the harassed individual, the court went ahead and granted an anti-harassment order for him. The Court of Appeals reversed that order because he was not the victim of the harassment, and that was acknowledged at the lower court level. In fact, that case pointed out that had the minister who had been the victim of the harassment been a party, most likely he would have been able to get an anti-harassment order. So that is consistent with the decisions below, in which my client appeared, and over the course of a lengthy testimony, much longer than I believe most anti-harassment hearings go, he testified to a 6-year pattern of constant surveillance and confrontation and close invasions of personal space, accusations of conspiracy and murder, some of which Mr. Lee touched on, all within close proximity. He also testified to the fact, and I will get to this, I'll go on to the other bases for review and why we don't think those are appropriate, but he also, it is important to know, testified, and Mr. Lee has never denied this, and in fact acknowledged this at trial, that he has never answered his questions, and he has indicated that he will not speak to Mr. Lee. So, turning to, so because these decisions are consistent with case law, we feel that that's an inappropriate basis. On the second, the discretionary review may be granted if the significant question of law under the Constitution of the State of Washington or the United States is involved. We submit that a significant question is not involved. This is, Mr. Lee mischaracterizes the order in his discussion of the photography. He's not actually prevented from filming Mr. Novoselic or reporting on Mr. Novoselic or anything like that. And it simply, Mr. Lee is asking the court to say, well, no, in the interest of, even though you admit that you cannot get an answer from this man, he has told you he will not speak to you. Mr. Lee, I think, believes that by catching, he believes that by filming him, he catches, actually, I won't characterize that because I'm not sure what Mr. Lee believes on that. He hasn't been that clear about what he anticipates getting from Mr. Novoselic, given that he will not get an answer. But as I say, there's nothing, the Brandsburg case that's cited in the brief points out that reporters aren't allowed to harass people simply because they're reporters. 3, more briefly, if the decision involves a review is proper, if the decision involves an issue of public interest, which should be determined by the appellate court. We addressed that in the brief, but essentially, to touch briefly on that, we don't feel that this is an issue of public interest, which should be determined by an appellate court. We cite cases, there's not that much guidance on this, what is an issue of public interest, but the cases I was able to find indicated that you look to see if things are capable of repetition, highly capable of repetition. Cases looked to things like how fact-specific was the underlying decision. This is a very fact-specific decision. This isn't a blanket prohibition on anybody reporting on Mr. Novoselic. This is a very specific, looking at the conduct of one individual and making rulings on those conducts, a limitation of the way a time, place, manner restriction on the way that individual can continue to perform this.
You've pretty much used your time. I'll give you a minute just to wrap up if you want.
Just to wrap up, and this is the last point, but if the Superior Court is so far departed from the accepted and usual course of usual judicial proceedings or sanctioned such a departure, Mr. Lee has not cited any such departure. He's merely recited a couple of remarks by the judge. And then I guess, sorry, my motion for sanctions, I'll just go ahead and let that stand on its own. Thank you.
Thank you. Mr. Lee, you have about a minute to reply if you'd like.
Well, in case it's not a part of the record now, can I offer 3 pages of the official transcript, Commissioner?
Do you have a copy to give to?
Yeah. It's 3 pages of her transcript, the transcript.
You can hand it up
by-
to me. If anybody, if there's some kind of an objection to it, just go ahead and file something in writing.
Well, the important thing about the 3 pages is that I didn't want to leave that out of the materials in total that have been provided to the court, because these 3 pages are the crux of the Roy Stocker decision. And let me just point out very quickly just a few things about his decision. Page 107, he says that I sent a letter unsolicited to the petitioner's mother. This was sent in care of his mother. On one occasion, 6 years ago, does Judge Pro Tem Roy Stocker really believe that an investigative journalist sending one-page letter to someone's mother's retail business address on one occasion demonstrates a 6-year course of action? That seems highly implausible. Obviously, that would be crippling to investigative journalists if that were to take root as law. On page 108, he says that there are time, place, manner restrictions that can be organized which will not compromise Mr. Lee's ongoing First Amendment privileges. In fact, I think that counsel is wrong. I don't think that this court proceeding is, strictly speaking, part of the Open Meetings Act, which means that I would not be restricted by 25 feet from the range of Mr. Novoselic, for instance, in covering litigation that he's involved in. I'd be restricted by 50 feet, which in fact would put me outside the building in most cases, otherwise subject me to arrest. It's completely unworkable. At the bottom of 108, the judge says that I can undertake my job under the First Amendment, I just can't be in his face. Well, I just can't be within 25 to 50 to 100 feet of his face. It's completely unreasonable. And on page 109, Judge Roy Stocker is equating my speaking at public forums, including giving testimony to the Seattle City Council on issues which are somewhat off the mark, according to him, as verbal assaults. I'm not sure that speaking to the Seattle City Council or otherwise engaging in political reporting can be characterized as a verbal assault. The assaults which occurred on my person by the comrades or the subordinates to Mr. Novoselic are undeniable and are part of the record on videotape. There was no finding that I assaulted anyone in any way. But there is this quasi-language about arguably assaultive behavior and verbal assaults. These issues need to be addressed in the appeals process, because otherwise the idea that a public figure involved in the highest degree of controversy can lay down $49, go to district court, make a series of malicious, baseless accusations against a prominent journalist, and then win this victory will have a chilling effect on free speech, and particularly in investigative journalism, as long as the case stands.
Thank you very much.
Thank you.
I'll be issuing a written ruling.
The element for the substantially altering the status quo has been met by virtue of the fact that a decision by the court to place the child in Nebraska in essence precludes my client from the weekly visitation that she was receiving, and they did not address that in their brief. So the real issue before this court is whether there's been probable error. It is our position that the Superior Court committed probable error under two different statutes, the first being the Indian Child Welfare Act, the second being RCW 1334.1.24. The Indian Child Welfare Act, the specific provision is 1915B, which deals with placing an Indian child either in foster care or pre-adoptive placement. In this case, the placement is anticipated to be pre-adopted, although the placement also does have a foster license. So in either case, that was our position that the criteria is placement be least restrictive setting, which most approximates a family in which the child's special needs have been met. That is not being contested in this matter. It's the second provision, which says the child shall also be placed within reasonable proximity to his or her home, taking into account any special needs of the child. It is in this case that we believe that the word shall is very important in this case, and it imposes a mandatory duty to place the child within reasonable proximity, again taking into account the special needs. In this case, the department and the court had an opportunity to investigate a local relative of somebody within the exact same county that the mother resides, and both declined to do any sort of investigation and instead placed the child at least 1,000 miles away from her mother in a very secluded area. I think it is important to note that the mother's issue here is that there was no investigation whatsoever of the local relative, either by the department or by the court. We had specifically asked for an investigation. We were not asking at the time of our response to the department's motion for placing the child to actually place the child with there. We conceded there hadn't been enough information provided, but we did not think it was unreasonable for the parties to actually do an investigation. In terms of RCW 1334.1.2, in this matter, this is a new statutory provision which we believe is designed to help facilitate voluntary relinquishments. And again, that language says in cases where a birth parent has indicated their intention to make the voluntary adoption plan for the child and has agreed to the termination of their parental rights, the department shall follow the wishes of the birth parent regarding the proposed adopted placement of the child. If the court determines that the adoption is in the best interest of the child, and the proposed adoptive parents are chosen by their birth parent are properly qualified, it is our position that there are several criteria in this provision, and in this case, our client indicated her intention, both herself, although she is incompetent, her guardian has also indicated the intention to pursue voluntary adoption if the parties want to consider this the local relative. Our parent agreed, and again, both the guardian and the birth parent agreed, and the court determines adoption is in the child's best interest. That matter has already been clearly agreed to by all the parties. This has been a matter that has been agreed to since the beginning of the pregnancy. And the prospective adoptive parents are all aware. But it's that last provision that we cannot form any opinion about because, again, there was no investigation. It was a summary dismissal of the mother's proposed placement. The department in this case is arguing that they seem to ignore the requirement of reasonable proximity and focus solely on the child's special needs in this case. But I guess I want to put it, there's been no record that this particular child's CFSC has really special needs. However, we will stipulate that he needs a stable placement, but they seem to make a lot of summary conclusions about this relative again, when there's been no investigation.
Hey, good meeting.
And again, the statute says shall be placed in reasonable proximity. Your argument, in essence, kind of seems to disregard any sort of need for reasonable proximity. They believe that 1,000 miles away is reasonable proximity, when again there's a possibility of less than 20 miles. Their main point also seems to be that the guardian in this case cannot consent to termination, and therefore RCW 125 does not apply. But even they point out that there can be the possibility of a guardian arrival appointed for the mother to help facilitate refreshment, which is what was going to be anticipated in this matter.
Let me just ask you one more question. What's your response to the department's argument that the interviewer in the association is part of the community?
Your Honor, I do have actually affidavits of service. They were notified. These are the originals.
Go over here. You have no right to do that. Actually, I do. You're going to put your hands on the hood of the car. Because you're being resistive and hostile. Put your hands on the hood of the car.
Is this the one you're filed?
Yes.
Hands on the hood of the car.
Moreover, in terms of the department's argument that the guardian cannot consent to termination because it would be a substantial right, the guardian did sign the agreed order of dependency. It was not a trial, it was a stipulated order of dependency. And although I will admit there's a distinction between a dependency and a termination, nevertheless it still involves a substantial right, and they did accept the guardian's signature on the agreed order of dependency. And again, this matter can still be resolved via having a guardian providing appointed for the mother. I think we can still proceed forward under 1334-125 in this matter. Both the Indian Child Welfare Act and the Washington statute don't really have any cases that have really addressed these kinds of issues, and we believe that is all the more reason that this matter should be taken up for discretionary review. And more importantly, given this child's particular situation, speed is of the essence. We do not have the luxury of waiting until either there's a termination and pursuing via an appeal of that to address this particular matter. The time that would take, the child will have been in Alaska and will have arguably bonded to these relatives will be such that I think it would be very, very detrimental to the child to have the matter reconsidered, possibly changed at that late date. So it's all the more important that the matter be taken up on discretionary.
Okay. Thank you.
Good morning, Your Honor. May it please the Court, I am Teresa Tsubo. I'm an Assistant Attorney General on behalf of the Department of Social and Health Services. The Department is asking the Court to deny the motion for discretionary review because the Department contends that the appellant has failed to show the Superior Court committed probable error in this case. The matter of MA, which is 66 Washington App 614, says in the absence of a showing of obvious or probable error pursuant to RAP 2.3, such appeals are discouraged because they frustrate the goals of judicial economy and efficiency. The Department contends that there's no error under either the Indian Child Welfare Act or RCW 1334-125, starting with 1334-125 and circling back the mother, or that the guardian
shorts. Look. Actually, let me do it. Hey! Look at my butt!
Crashed into the Pennsylvania countryside. His father, Abdullah, was a police